Mhm.
It is 2 after, so if you're okay, Renee, we can get started. All right. Hi, everyone. My name's Mark Weicker, and welcome to the Special Education Legal Clinic. This is a collaboration between Disability Rights Ohio, the Ohio Coalition of the Education of Children with Disabilities, and AW Law. And today's session is Procedural Rights and Dispute Resolution, which is going to be presented by Renee Stromski from AW. And a couple things before we get started. You'll see the URL at the bottom of the graphic there. The registration for the legal clinic, as well as resources and the schedule of upcoming workshops is available there, lawyersforstudents.com/legal clinic. And if you go to the next slide, Renee. Here's a kind of a list of what's available at the same URL. So you have current schedule of workshops. And one thing to point out, this is the second from the last workshop in the series. And the next one is going to be on the notice requirements or the updated notice requirements. And that's going to be put on by OCECD. And that will be the last in this series. So that'll be a July workshop, as usual, the third Monday of the month. And then we take August off, let everyone get back to school, and then start again in September with a series of about 8 workshops, 9 workshops maybe, focused on transition. So post-secondary transition to employment, to continued education, and independent living. And a series of workshops there, which are listed and available for registration if you want to register for any or all of them. Again, just like this one, those workshops are free, and we're excited about it. We've had collaborations with another law firm and lawyer. We have a collaboration or speakers from the Department of Education, a couple of those, and OCECD is going to kick it off with Section 5 of the IEP related to transition. And the other thing about these workshops is that they're all recorded, including this one. So usually a couple days after we have the workshop, they will be posted online right where you registered. So on the page, the same URL again, you can click on watch here and you can watch the recording of the workshop on YouTube. And the other thing we have at the website is a research portal for special education issues, and that's available again for parents, any attendee, but parents or educators. We've tried to pull together as many resources as we could for special education parents and educators to link them directly to laws and other authorities on special education. And then we have resources such as template letters from OCECD and tip sheets from Disability Rights Ohio available to help you through any issue you might have in special education. And then the last thing before we get started is that we do the workshops, and you might also be aware that we do individual guidance sessions. And those sessions are 30-minute sessions with an attorney or advocate, a lot of times me, Renee, and or Danielle, and sometimes attorneys from Disability Rights Ohio. And those can be scheduled through the same website. And again, 30-minute sessions, completely confidential, and we help you through your special education issues. And so that's it for me. And without further ado, I'll pass it on to Renee Stromski.
Thank you, Mark. Can you hear me okay still? Okay, great. And I just want to emphasize before I do begin that even though the focus of the upcoming workshop series is on transition, and that sounds like it might not be something that you have to worry about until later on, but I really do encourage you to start thinking about transition as early as possible. But today we are going to focus on your procedural rights and dispute resolution. And now we've got a lot to cover today. And I'm going to be focused on giving you as much facts as I can with, with all the time that I have with you today. But I do want to encourage you guys to use the chat to ask any questions you might have. And I'll have Danielle, hopefully, I know she's got her camera off, but hopefully she can monitor and just let me know if there are any questions. Thank you, Danielle. As they pop up, feel free to interrupt me, and then we'll have some time at the end as well for questions. But just before I jump right in, like I said, a lot of information to cover. We're going to be talking specifically about the Individuals with Disabilities Education Act today. The IDEA is our acronym. And the IDEA is our law that guarantees students the right to a free, appropriate public education. And the IDEA is also what outlines our various procedural rights and safeguards that protect the rights of students and parents, So that being said, this is where that's where our protections are coming from, is this law, the IDEA. It's very important for us to remember. And I'm trying to switch the slide. There we go. So what are procedural safeguards anyways? I mean, I feel like this phrase is just thrown around. It's overused for sure, but I feel like we don't necessarily always know the meaning, and we get this wonderful, I wish I had made it a little bigger. It looks small now, but we've got this wonderful guide to parent rights and special education that we get every month. But what is in this packet? It's really important. These safeguards or these rights, they are guaranteed under that IDEA. They're a guaranteed legal protection that you have as a parent for your student with a disability, and this right that the parent has also transfers to the student at age 18, and that's under the IDEA. So these are really important. This is what these explain the school district's responsibility to you or to your child as a student with a disability, and then outlines what you can do if you are having a disagreement. And of course, I'm going to get into all of that, but just as an overview, again, I know that procedural safeguards, procedural rights, whatever you want to call them, really what it is your legal rights. And that's really these rights, again, just to emphasize, it's for transparency between school districts and parents. And I'll say it's not just school districts, because the IDEA reaches to any school receiving public funding, so it can be community schools as well, but really just opening transparency of communication between the school and the parent, and to help ensure accountability for the schools to provide what they are obligated to provide for the student, and overall fairness as well. Now, there are specific procedural rights that are outlined under the IDEA, and that you will see. Again, let me just back up a slide. Again, this really, the guide to parent rights and special education. This has all of your information at it. So I know that you get a copy of it, or you should be getting a copy of it at every annual IEP meeting, or or anytime there is a proposed change of placement, or maybe possibly disagreement. What I'll say is that this is really important. I know that we get different copies of it, but I want you to keep it and hold on to it, because it has all of this information in it, and it's right in front of you, and you can access it online on ODE's website. So moving forward, these rights outlined in the Guide to Parent Rights are the parent's right to informed consent. And then there's also the right to participate in meetings and decision-making processes. The other parental right is the right to an independent educational evaluation, an IEE, the right to be informed of their rights, and that's through a prior written notice. And then the Guide to Parent Rights also outlines the parent's right to review education records. Although this isn't necessarily protected by the IDEA, it is protected by FERPA. Most of the dispute resolution that we'll be talking today is through the Ohio Department of Education within their Office for Exceptional Children. For any concerns related to reviewing education records, it would be a complaint through FERPA or through a violation of FERPA, still through the Department of Education. So a closer look at these different rights that the IDEA outlines for parents. First, that right to informed consent. And this, we've got a lot of cases coming in of what exactly is informed consent and how much does a school have to tell us about what they're doing, what services they're providing for the student, whether they're changing the student's placement. But really, the IDEA specifically outlines that parents need to be able to make informed decisions about their child's special education services. And because of that, schools are required to provide informed consent to the parents to ensure that they have access to all the relevant information. And really, this is the key phrase, all of the relevant information necessary to meaningfully participate in the special education process. So we're talking about, we'll talk about prior written notices in just a little bit, but, some of these these requirements for communication of informed consent to make sure that you have that relevant information is just making sure, okay, do you understand what's going to happen if we are moving your child to a new classroom, if it's a more restrictive environment? Okay, what's happening if we're actually removing your child from services? The information that they provide you for that consent has to be able to ensure that you can meaningfully participate. And again, that comes from, or that is part of the right overall to participate in meetings and the decision-making process. And really, this is just overall acknowledging that parents are essential members of the IEP team. And it recognizes the parents' unique knowledge and insights about their child's needs, strengths, and preferences. So it gives parents the right to request an evaluation, the right to attend IEP meetings, again, with that requirement to provide informed consent and allow meaningful participation in that special education process. So the other right that is protected under the procedural rights of the IDEA is that right to a prior written notice. And that, which I keep bringing up a couple times, so I'll dive into it. Now, the prior written notice is what must be provided to a parent or the parent or the child before any significant changes are made to the child's identification, evaluation, placement, or provision of special education services. Sometimes the prior written notice does not come until after the meeting happens. Sometimes it will come as a communication, but what it has to include overall is a clear explanation of the proposed changes that the district is going to make to the child's IEP or special education services, the reasons for those changes, a specific description of other options considered and why those options were rejected. And this is really, again, this right to prior written notice is just for ensuring transparency and accountability by requiring schools to provide parents with both through a prior written notice and that right to informed consent, providing parents with that clear and understandable information regarding the purpose, the nature, and then the potential risks and benefits of any proposed evaluation services or changes to their child's special education programming. And really, this is overall to help establish a foundation of trust between parents and schools. All of that to say, and this is kind of where we start moving into from our procedural rights into, okay, what can we do with those procedural rights and our knowledge of them, is your right to an independent educational evaluation. And so this is available to parents if they disagree with the school's evaluation of their child. In those circumstances, the school is required to pay for an outside evaluation. under certain but reasonable criteria. So usually schools are able to say, you know, it has to be within a certain a reasonable monetary limit. It has to be within a reasonable location distance from the school. And but you are entitled to one per every evaluation period. Now, include when you do disagree, when you have that right to an IEE, how do we exercise that? So this chart actually was provided. Oh, now I'm trying to remember where I got it from. I believe I got this chart off of the ODE website specifically, just helping explain how you can request or what kinds of are different, different ways that you can request the district to pay for that IEE, that outside evaluation. So, this is available when, you've already gotten an outside evaluation and you want the district to pay for the costs. The district might reimburse you. The district might also agree with your results and help you arrange an outside evaluation. But overall, sometimes the districts will still disagree and think that maybe an outside evaluation is not needed. And that's where we have our disagreements and we lead into that dispute resolution. And so dispute resolution really is needed anytime the school and the parent have a fundamental disagreement about FAPE. So with FAPE, we talked about that right in the very beginning when we were talking about our rights under the IDEA, that overall right to a FAPE, an appropriate education. When the school and the parent are having that fundamental disagreement, and that's related to anything related to evaluations, identification, change of placement for a child with disability and provision of special education services. If there's disagreement about that, that is where a parent can begin moving toward dispute resolution and use those options. And this is really, when the IEP team has exhausted all other options, maybe they've tried communicating with each other, maybe they've gotten another district representative involved, maybe you've gotten a parent advocate involved and things just aren't working. So, all the other options are exhausted. You're ready to, just have some extra support, whether it's through the Ohio Department of Education or what have you, but you're just ready or need that extra support in getting to a place with the school that you need to be for your child to receive appropriate special education services. And so dispute resolution is also needed when you need prompt intervention. And I'll say prompt. I don't want to also say immediate because there is a expedited process for more immediate concerns. But when prompt intervention is required, because there is a 60-day timeline for a resolution of complaints with the Department of Education, anytime that there's an intervention required, that's within, maybe 60 days or within that time frame, that is something that we can utilize for dispute resolution. We also, if there's a disagreement with a change of placement related to disciplinary removals, an expedited due process complaint can be submitted, a request for a due process hearing, and that will actually occur in a 15-day timeline rather than that 60-day timeline. So that's where, if you need that immediate intervention, okay, my child's been removed, they've had a change of placement for disciplinary purposes, that's really important, I need immediate intervention. There's availability for that as well. And now on this next slide, this is a chart provided by the Ohio Department of Education, and this is this is a beautiful outline for what you would use to, in cases where you'd like to use your dispute resolution rights. Hopefully the screen isn't too blurry for you guys. It's a little small for me, but essentially there are 6 different processes that the Ohio Department of Education has with regard to just resolving any disputes between schools and between parents. There is, like I said, there's 6, and from the left to right on this screen, the order of the different availability or options that the Ohio Department of Education has is maybe from your least intense to more intense, or possibly ones where we need a little bit less support from the Ohio Department of Education to maybe more support. So we'll go into those a little bit more just in a second here, but I really just want to pause on the screen for a second because it's important to know that there are a lot of options for dispute resolution. I know a lot of times people can, come to a law firm for help, at least in our case, come to AW Law for help with, or just thinking that the only option moving forward is litigation. But the Ohio Department of Education offers these awesome resources for dispute resolution right within their administrative processes. And these, of course, are things that, AW Law is very capable and happy to handle and help. And it's just to show you guys that it's not always just litigation. These can be things, mediations or hearings, or even something as simple as just giving ODE a call and asking for more information. So just to get a little bit more in depth to each of these, the first option on that spectrum is that early resolution. So this is an informal process that might alleviate the need to file a formal written complaint or a due process complaint. It provides a further explanation. There are education specialists that are available through the Ohio Department of Education that are available to provide further explanation about federal and state laws that relate to special education, and most of this is related to the Individuals with Disabilities Education Act. They also are able to, help describe some of these dispute resolution options that are available to parents, which I kind of covered a little bit, and which I'm going to go into depth a little bit more here further. The Ohio Department of Education within early resolution, ODE can also inform parents of procedural safeguards, what we've already talked about, your right to informed consent, to prior written notice, to meaningful participation, and your right to an IEE. And early resolution, these education program specialists can also just identify any other agencies and support services that might be helpful. I'm guessing, I guess I'm not totally 100% confident, but I would guess that the Ohio Department of Education at least might refer to Disability Rights Ohio and the Ohio Coalition for the Education of Children with Disabilities, just as nonprofit organizations. But just as an example of support services that early resolution can provide to a parent. And then again, it's just discussing, or they're able to describe available remedies that are available to the parent and to their child, and how parents can proceed. So again, the educational program specialist isn't going to give you legal advice and say, okay, based on your case and what you're telling me, you should file a complaint, or you should file for mediation, or you should file for the IEP meeting, or for a facilitated IEP meeting. Unfortunately, that is not what the education program specialist does. They can tell you what is available, what's available out there and what you can do, but they can't tell you how necessarily, or what you should do to proceed. That's where we come in, where Mark and I come in, at least as special education attorneys, where we can help with our clients, give that legal advice as to, okay, we have all of these, I'll scroll back to it again. We have all of these wonderful, wonderful different options of dispute resolution. What Mark and I are there for is to help parents, just to help parents choose, what really is available, what remedies are available to them dependent on the different avenue they choose to pursue, and what's in their best interest. And so this is all, although that's a little bit I would say that that's a little bit misleading, that ODE says that they can tell parents exactly how they can proceed. That's more of the attorney's job, where you can, get advice from us and see what we can do to help. So following early resolution, if a phone call to ODE, call up ODE with a question, maybe you just want to clarify the law on something, maybe you just want to clarify the terms of the least restrictive environment, just making sure that the child has to be educated to the maximum extent possible with their non-disabled peers. Perhaps you've called them up, you've called ODE, the education program specialist, they confirmed that definition. There's a disagreement related to a child's change in placement to a more restrictive environment. You take that information back from ODE, you take it to the school district and say, hey, ODE says this is a change of placement. I think there's a dispute here. I disagree about this change of placement. And they're saying, hey, we don't care, or they're not listening, not receptive to that. That's where you can move on to that next step of facilitation. So what ODE also has is a great program where you can request an education program specialist or an IEP facilitator. And the facilitators are usually the same employee or the same staff members who work as mediators as well. But essentially you can request from ODE to have a facilitator assist the IEP team during meetings and being productive and keeping the focus on the student. So the IEP facilitation would take place. It can take place in any team meeting, but most of the time it takes place in an IEP team meeting or an evaluation planning meeting or an evaluation team meeting. So really just anything related to the special education services, you can request a facilitator be present just to keep that focus on the student. And like I said, the facilitator is, it's not someone who's going to advocate on your behalf. It is someone who's a neutral third party who is just there to help assist everyone in being productive and keeping focus on the student. They are not acting as a member of the team. They're not making any decisions for the team. They're not providing advice to the school. They're not providing advice to you. That person is just there to help make sure the conversation is focused on the student, and maybe if there have been high tensions in the past, hopefully keep the meeting as relaxed and calm as possible. Facilitation has been very helpful. There are wonderful facilitators / mediators over at ODE who really do a great job, or the ones that I've worked with at least have done a great job of just ensuring that if anybody gets off topic during a meeting, or maybe the meeting starts to become too argumentative or too defensive on either side, the facilitator has been good about jumping in and just having great phrases and great ability to redirect the focus of the conversation back to really, okay, at the end of the day, we are talking about the student here. What does the student need? And what are the district's obligation, or what are the school's obligations to provide to that student? Again, if you need that person, that facilitator, again, like I said, it's a neutral person who's not helping you make those decisions. If you do need someone to help make those decisions, that's again where your wonderful team at the Special Education Legal Clinic can come in. Next, if the IEP facilitation meeting hasn't worked, or potentially you just skip to this one, mediation is always an option. And I'm just going to pause to take a sip of water. Now, mediation, you could potentially you could do this after a facilitated IEP meeting, although maybe it's separate. But mediation, really, it's keyword, it's a voluntary process, and it's for resolving disputes between two parties. So that keyword is voluntary. So for mediation to occur, both sides must agree to mediate. So you cannot be the force, or I apologize, the school cannot force a parent or a family into going to mediation. Both parties have to agree. And at the same token, even if a parent does want to mediate, the school district has to agree in order for a mediation to occur. Most of the time, and it does depend on the situation, of course, but most of the time I do see districts agreeing to mediate because, when we get into some of these these next options, they can be a lot more intense and cause a lot more work for the school district. And so if there's anything they can do to try to resolve the issues as quickly as possible, that's what they want to do. So these mediations are really important because the parents and the school are, it's just short of filing a complaint, it's helping to be more in control of the outcome of a resolution between the parties, while keeping the focus on the student. And, you know, a lot of times parents can be more satisfied with the outcome with the school. Well, both parents and the school can be more satisfied with the outcome when they've been able to work out that agreement together, rather than filing a complaint and having the Department of Education or an administrative law judge make that decision for them. It's also better. It's also better in terms of being able to understand the other person's point of view, and can help settle issues a little bit more quickly. And it's also free. You don't have to pay for these services. But overall, again, it's still facilitated by that trained impartial third party. Like I said, I'm not sure, I can't say for sure with a certainty, but I would say most of the mediators that I know also act as IEP facilitators. So a lot of them kind of wear both hats. I'm not sure if there actually is anyone that only does one or the other. I could be wrong. But that being said, that person is there in that mediation, again, to help those parties communicate with each other, and discuss the issues at hand, and just make an effort to help reach a mutually acceptable solution. And really the point of mediation is, again, compromise. That's where sometimes we have to let go of things on our side, and sometimes the district lets go of things on their side, but it's all in an effort for, okay, we've got a dispute at hand. We are going to agree that we disagree, and here's what we're going to compromise on moving forward. And that can be a very detailed and outlined plan. But again, as a reminder, the mediators, although they are super wonderful and do a great job, again, of keeping that focus on the student and keeping both parties on track to the matter at hand, the mediators also not a representative of the parent or the district or school. And that being said, they won't advocate on behalf of the student. They won't tell you if the school's ripping you off with their mediation. You know, they aren't going to tell you if this is in your best interest. They won't tell you if, you know, they've seen the school settle for more. They won't give you kind of that insight. That's where you would want to have an advocate or an attorney supporting you at that meeting to make sure that you are getting the most out of your settlement, the most out of your compromise, to make sure that the student is in the rightful position moving forward, and that the school is fulfilling our obligations while also keeping in check of ensuring that we're asking for what's appropriate for the child and not anything above and beyond. And so again, that's just, this mediation is available in short of, or in lieu of filing a complaint. If there is a settlement agreement, that typically means that you have to dismiss any complaint that you may have filed. You also can just file for mediation independently of filing a complaint as well. In that case, you wouldn't have to dismiss any complaint. So if you do decide to file a state complaint, ODE actually, and I just want to stop for a second, because ODE actually just, I think they changed it for the better, but just on May 15th, so just about a month ago, they updated some of the names for what they were calling their different complaint processes. And before, they were just kind of labeling all of their complaint processes under one category, and it was all mixed up. And I think it was a little bit difficult to kind of pick apart the difference between the complaint types and what would be most appropriate for you and your child. I think the new update that they have explains it a little bit better. And so it really separates the difference between filing a state complaint and requesting a due process hearing as your other options for moving forward with dispute resolution. We're going to talk about filing a state complaint first. So the Ohio Department of Education, they have an effective complaint investigation process. They have procedures and investigate issues in order to resolve them in a timely manner. Essentially, any time that you believe that the school has violated the Individuals with Disabilities Education Act, and that goes back to the school, whether there's a fundamental disagreement about whether the school is providing the student with a FAPE. And these are times that you can use this complaint process. What you can do, the complaint process is also supposed to be pretty user-friendly for parents to fill out, although I will say it can be very helpful to have someone work through the complaint with you to help identify the violation specifically. But essentially, it's pretty user-friendly in that you just have to fill out, what act of discrimination you believe is occurring, what your attempts to resolve it have been, and what you believe the remedies would be for a successful path forward. So ODE, when they receive a complaint, they will review it, and if they see a violation, if they believe that on its face the complaint states that there's been a violation of the IDEA, they will go ahead and open a complaint for investigation. If they're not sure, if they think they need some more information before making that determination, they might ask you for a quick phone call just to ask some more questions to, see if there has been a violation of law. And what they'll also do is just, make sure they review, if they don't open the complaint, if they don't open the complaint, if they don't see a violation at all, they just won't open the complaint. So when they do, in those cases where they do open the complaints, they'll review them within that 60-day timeline. They'll ask the school district to provide different various forms of documents, and be able to review from that internal side of, okay, was the district performing their legal obligations, or has there been a violation of the IDEA, and did that affect the students, or did that affect the district's ability to provide that student with a FAPE? They will review and go through that, and they will determine whether there were any violations. And along with those violations, they will issue corrective actions to the school as well. And so that, what that looks like is essentially, if the school goes through and they identify that there have been different violations of the law that have resulted in a loss of a free, appropriate public education to your child, they will issue, like I said, corrective actions, or just kind of orders or demands for this school to follow through. And the school is required to follow through on those. Otherwise, the Ohio Department of Education will revoke their funding. So some of these corrective actions that I've seen, or mainly look at training for staff members, administration, to ensure that, the requisite knowledge is possessed by the staff members, and to ensure that the similar violations don't happen moving forward. There is also, I've seen, as well as training, there's also compensatory education. So if there's a complaint about a student who on his IEP, it says that he was supposed to get physical therapy every other week during the school year, and you found out that he didn't receive any physical therapy during the entire school year. The compensatory education there, or I should say the compensatory services there, because it's related to physical therapy, not education. But those, you would request for those services to be compensated back to the student, or ODE would ask that those services be provided back to that student. So if he was supposed to be, this is my quick math here, if there's 40 weeks in the school year and he was supposed to have 20 therapy sessions for an hour a week, or 20-hour-long sessions, then the school would owe him 20 hours of those physical therapy services. What you have to remember about the ODE state complaints is you have to file within 1 year from the date of the violation. So if there was the entire school year, your student went without PT services and we just hit the end of the school year or the end of that IEP term on June 1st, you would have June 1st until next year, or probably, I guess, May 31st next year to submit that complaint, to make sure that that ODE has jurisdiction over it. I do want to point this out. Unfortunately, we're not at the point yet where statute of limitations with relation to special education claims toll the same way that some other claims with relation to childhood claims do. So it does have, the complaint does have to be submitted within a year from the violation. There is no, unfortunately, we can't use yet, hopefully someday in the future, but unfortunately right now we can't use the argument that you know, the child's underage and can bring a claim right now. It has to be within the current year. So that is one of your options, is just filing the state complaint and having ODE come in, do their investigation, and have an answer within 60 days. And ODE will say, okay, yep, you know, school district did something wrong. Here are the corrective actions, and we're going to make sure that the corrective actions are followed through on. They also could come back and say, nope, we don't see a violation, and that's kind of it. There are some other, the next option, there are options for appeal, but it's kind of going into this next dispute resolution option. So that's where I'm skipping ahead to, is that you can also request a due process hearing. So what you can do is request an impartial hearing related to the student's due process rights, to help resolve disagreements about anything related to, again, those students' due process rights, which relate to the identification, the evaluation, and the placement of the student, and again, whether that student is receiving a FAPE. And so when you have any concerns of this, I'm not, now that they've changed it for the past month, I'm kind of blanking on the different, they might have had an informal and formal complaint. I can't remember how they had it labeled before, but now to properly identify it, the state complaint is specific to those written formal complaints that ODE takes care of, whereas due process hearing is more, I think, actually specified and kind of pointed out that it is an actual hearing. This is something that the IDEA requires happens prior to any litigation in federal court occurring. So I know a lot of times we have potential clients coming in, or just consults talking about thinking about being ready for litigation and wanting to take that step with the school district. However, due to the IDEA, we have to exhaust our administrative remedies first for the most part, and in most circumstances, prior to filing anything in federal court. So this would kind of be almost looking similar to what a federal courtroom, so to say, would look like. It would be your hearing. Both parties would get an opportunity to present their side of the argument. You would get your opportunity to call witnesses who can testify to your students' needs, to your position as to why whatever you are requesting is a free, appropriate education for your child. And the school can also call their own witnesses and present their own evidence about why the student or why their position is right, that the student might not need these services or what have you. And you've got, like I said, you've got an impartial hearing officer, an administrative law judge. Depending on, I was going to say it's an impartial hearing officer. I keep saying ALJ. I think that's Michigan though. Hearing is conducted by that impartial hearing officer. So it's similar to an actual judge in a court where you have that person making the decision at the end of the day. And I apologize for the misspell. I don't know what happened here. I apologize for the misspelling in this sentence. But we have, in regard to the due process hearing, usually these timelines are they're pretty quick, but they can still take some time. It can take at least 20 days to set the disclosure conference, and it can take a couple months to get through setting up all the witnesses and getting through the hearing itself. But there's an expedited timeline set up specifically for any changes in a student's provision of FAPE or their placement or evaluation identification when it's related to a discipline hearing. That expedited timeline is then 15 days. So if you have a dispute related to, mostly that's for expulsion. So if a child has been expelled or removed from the, removed from the school for more than 10 days in a school year, either 10 consecutive days or more than 10 days in one school year related to the similar instance, you can request that expedited timeline, just because at that point we know that the child is missing out on school and we need to do something immediately to make sure that child can receive an education. The due process hearing it does give us that extra year where the complaint can be submitted 2 years from that violation. Again, we unfortunately don't have that ability to use the excuse that, okay, maybe our student is only 10 years old now. We can wait until he's 18 and then wait another 2 years from that violation. Unfortunately, that is not an availability. And Danielle, I see you popping up. Is there a question?
Yes, we do have a question. So I was going to read it out to you and we can walk through it and answer it. So Rachel asked, how do you know the allotted minutes for various therapies are maximized throughout the year if the district refuses to enforce days and times seen in writing? What if therapists are absent, or what if her child is entitled to the minutes lost? So I think she's asking about the SDI minutes on the IEP and what happens, because we don't always know, right, if it's enforced. We just, it's supposed to be, right? It's supposed to be, we're hoping it is.
Yeah.
So in reading through this, I mean, my answer would be, certainly the school district would have to make up that time. So if there's 180 minutes a month on the IEP for speech services, and that that's not being met because of maybe staff absences or staff turnover, whatever it may be, then you certainly could ask those minutes to be made up. It's considered compensatory education because they're owing that time. But I think it sounds like maybe they're not realizing that they're in the wrong, and you as the parent are saying, wait a minute, my child's owed services.
Yeah, I totally agree with that as well. I would say too, exactly, it would be compensatory services. And if the IEP team made this decision, I keep using physical therapy as an example, but this extends to reading, writing, math, all of your academics. If the IEP team decided that in order for your child to receive a FAPE, they needed that 20 minutes of PT a week or whatever, I keep changing it, then they are required to provide that. And if they're not providing the student with a FAPE, and that's a violation. So that's kind of where you can make that argument that, yeah, the minutes are owed because you said that you said this was needed, right, for that appropriate education, but you're not providing it. So he must not be receiving one. Hopefully that's answered your question.
If not, let us know.
If not, let us know. Of course, let us know, please. I think I was just finishing up this slide, just getting into the just that the violations have to be submitted within 2 years. Again, tolling unfortunately not allowed. And that is or what I should say before I go there. If the due process hearing does not go in your favor, we're really talking about ODE today. If the due process hearing does not go in your favor, there is then the option to, if the case lines up with it, if you have good facts, if you have a good case on your side, there's the ability to appeal any of those impartial hearing officer decisions into federal court, and start that litigation process as well. But focusing again on our administrative remedies, I've just gone through that entire timeline. If you remember the entire wonderful chart that's on the ODE Office for Exceptional Children website, but I just want to touch on really quick. OCR, the Office for Civil Rights within our U.S. Department of Education, has an administrative remedy as well. They are responsible for, while ODE is responsible for protecting rights under the IDEA, OCR is responsible for protecting rights under Section 504 of the Rehabilitation Act and Title II of the Americans with Disabilities Act. So they, which still overall prevent or limit discrimination of students with disabilities. So it still protects those IDEA, or it still protects some of those similar IDEA protections, not all of them. However, if you do have a student on a Section 504 plan, ODE will not have jurisdiction over them because they only cover the IDEA. OCR is where you will go if your student has a Section 504 plan. Again, this is the U.S. Department of Education. They have a shorter timeline, 180 days. And now I'm seeing I double checked the presentation, of course, before I came in. Now I'm seeing the typos, but the complaint must be submitted within 180 days from the violation. 30 days a month, that's 30 days in a month, that's about 6 months. So it's an even shorter timeline than that Ohio Department of than the Ohio Department of Education 1-year submission deadline. So it's pretty quick. U.S. Department of Education, they're also covering a lot more than just disability discrimination. They take care of race discrimination, sex discrimination, age discrimination, a lot of different other facets, as well as pre-K through college and across. At least the office that covers Ohio covers Michigan as well. So they've got a lot of cases on their hand. They've got a lot of cases on their hand is where I'll leave it. But they still are an available remedy, especially to our students with Section 504 plans. And I know that I am running a little bit low on time, so hopefully there's not, oops. Sorry, I switched the slide. So hopefully I don't have too many questions at the end. If we do, that's okay. But just a couple quick tips for a successful resolution. And then if there are questions, I'll just answer them right after this, since my last slide. But focusing on just getting what you want, getting through your concern, getting the school district to understand your position. Start with getting to the rule. That is just focusing on some of those key phrases that I've highlighted. FAPE, an appropriate education. Is what your student receiving appropriate? School districts, we all want what's best for our children. School districts are only obligated to provide what's appropriate. So it's where we want to use our language and our argument and get to the rule and show, yes, it's not that this isn't just me saying I want what's best for my child. This is what's appropriate for my child. And without it, they won't be able to make adequate progress toward their education. For a successful resolution, we would always begin collaboratively. Compromise is always good. Especially if you have a long time with the district, and it could be some, there can be some give and take with the interpretation of the interpretation of the meaning of appropriate. So it's important to just start collaboratively and model good behavior at the same time. It definitely can be an emotional process and it can be frustrating, but just always assume that a hearing could be the end, what happens at the very end. And you always want to look your best for the judge, especially because school districts get a lot of deference at the end of the day from the judges or from the hearing officers, I'm sorry. So we want to be on our best behavior and not really give the school or anyone any more reason to work against us than we have to. Of course, and finally, utilize the spectrum of available resources that you have from our website, of course, and from OCECD and DRO as well. Finally, okay, good. It's 12:55, so hopefully I'm still in a good time, but I just wanted to bring up this picture once again. This is your guide to parent rights and special education. Very, very important. You really only need one copy. It's available online, so it's okay if you've recycled or shredded them all. Look it up online. It's right there. It's got all this information. Be aware of your rights. Utilize the advocacy tools, and just remember that you are your child's voice. You are that person with the rights. If someone if you aren't the one speaking up for your child and advocating or advocating for their rights or disputing any disagreements, then nobody else is. So this is in your hands and you have this ability. And I will turn it over to Mark to conclude for us. And then I'm sorry I took up so much time, and I'm always open for questions, but
You're
go ahead.
welcome.
Oh.
One question I was waiting to pop in with.
Okay.
All right, so Melissa said, if my child is absent because of illness, is the district required to make up those services? Her daughter was out for 2.5 months for heart surgery.
I jumped on to help out with that too. But yeah, I know this because I've dealt with it recently, that the guidance from OSEP is that they look at it on a case-by-case basis, like what the basis of the absence was. So there are lots of circumstances where a child might be out. It may be an excused absence like this one. It may be unexcused. It may be related to any number of things. So the official vague guidance from OSEP is that it's determined on a case-by-case basis. But so it's not, so the answer is no, not necessarily are they required to make up the services, especially when the child is absent, again, for either a good reason or a not good reason. On occasion, we have clients who are habitually absent or end up truant, but the school, the services are typically provided in the school setting. So that responsibility is fulfilled if they have a therapist, for instance, ready, willing, and able to provide the service, but the student's not available. However, what typically happens in these situations is, look, you have an extended absence for a very good reason. In this case, you negotiate with the IEP team and say, hey, we missed 2.5 months of therapy. Is there a way we can make this up when she returns? And you have to consider whether or not making that up in a short amount of time is going to be, burdensome for the student. That sometimes it's just not possible, or it can be overwhelming, especially with instruction, can be overwhelming. So if you really have to regroup with the IEP team and say, how much of this can we make up and when, and what's feasible for the student to accept and take. So that's the answer. It's not a real clear answer, but if you're looking for a short answer, if the school's ready, willing, and able to provide the therapy in school and the student's not available, then they've largely fulfilled their obligation.
And I was going to say, I think a lot of that is being proactive. If you know your child's going to be out for an extended period of time, then talk with your district about that, because a lot of districts will provide services, whether it's virtually, or they will link up with the hospital to where your child's at, or have providers come to the home which your child's recovering. But I think just being as proactive as you can allows the district to get those things in place.
Yeah, good point. All right. I think that's it for the question. So I'll wrap it up. Just want to say thanks to Renee. That was a great presentation. I learned a couple things myself, and thanks for everyone for attending. We plan to continue the clinic. We've had a great turnout so far. These have been fun and informative, and from our perspective, a great collaboration with DRO and OCECD. So thank you everyone for attending. Please do sign up for the next workshop, one more in this series again. The updated notice rights or notice obligations under IDEA. And that's going to be presented by Tammy to Sebastian from OCECD, who is a part of the committee making those updates. So that'll be next month, third Monday. And then of course, like I mentioned, we start the new transition series in September, and those are available to register for now at that URL at the bottom of the screen there, lawyersforstudents.com/legal clinic. Thank you, Renee, and thank you, Danielle. And I think that'll wrap it up today.
Thanks, Mark.
Have a good day, guys.
See you next
Bye-bye.
month.